Hello everyone, welcome back. You're watching Easy Legal and today's topic of discussion will be on information given to the police and their powers to investigate such cases, which falls under chapter 12 of the Criminal Procedure Code 1973. Usually in a society where people exist, crime also exists, and whenever any crime or offense happens against any particular individual or against the society or against any other person, in such a case the Criminal Procedure Code 1973 provides a remedy to the people that the particular person can go to the nearest police station and furnish the information regarding the offense or the crime which has happened against him or against any other individual or against the society, and such information must be written down by that particular police officer in charge of the police station, which shall be known as the first information report. This particular term, first information report, that is FIR, has been discussed under section 154 and 155 of the Criminal Procedure Code 1973. Under section 154, the information regarding cognizable offences has been discussed, and under section 155, information regarding the non-cognizable offences and the investigation regarding such offences has been discussed. I have already made a video on the classification of offences, that is difference between cognizable and non-cognizable offences under the Criminal Procedure Code 1973. You may watch that video. Usually in cognizable offences, the police officer has the direct authority to arrest the person without a warrant, and the police officer has also the right and the authority to investigate the case without the order or permission of the court. Whereas in non-cognizable cases, such a right has not been given to the police officer. The police officer cannot arrest a person without a warrant, and the police officer cannot investigate a non-cognizable case without the permission of the court. Basically, under section 154 of the Criminal Procedure Code 1973, any information regarding a cognizable offense, whether orally or in writing, been given by the informant, shall be reduced to writing by the police officer in charge of a particular police station, and the informant, after reading that particular information being written by the police officer, sign that particular FIR, and whose details shall be recorded or registered in the police station diary as prescribed by the state government to the police officials. This is mentioned under subsection 1 of section 154 of the Criminal Procedure Code 1973. A proviso was added after the Criminal Procedure Code 1973 Amendment Act 2013 to section 154 subsection 1 of the Criminal Procedure Code, that any offences committed against a woman falling under section 326A, 326B, 354, 354A, 354B, 354C, 354D, 376, 376A, 376AB, 376B, 376C, 376D, 376DA, 376DB, 376E, or section 509 of the Indian Penal Code. In such cases, in such kind of offences against the woman, the information by that particular woman victim shall be recorded by a woman of a police officer or a woman officer being authorized by the law. In any kind of offences against the woman, the information of the offence regarding that particular woman victim shall be recorded by a woman police officer, and provided further that when any offence against the woman has been committed under these sections of the Indian Penal Code, and that the woman is physically or mentally incapable of furnishing the information, or who has become temporarily or permanently incapable of furnishing any kind of information to the woman police officer, in such a case, the woman police officer shall record or videograph the information to be given by the woman victim in the place or in the residence where the woman victim wants to furnish such information, according to the convenience of the woman victim. And such recording of the information shall be done in presence of a judicial magistrate. Subsection 2 of section 154 states that a copy of the FIR, that is the first information report, must be given to the informant who gives the information regarding the offence to the police officer, free of cost. The copy of the FIR must be given to the informant free of cost. Subsection 3 of section 154 of Criminal Procedure Code 1973 states that whenever any police officer denies or refuses to accept the information being given by the informant, then in such a case the informant has a right to furnish such information or to send such information either in the form of writing or by post to the superintendent of police. Thereafter, if it appears to the superintendent of police, or if it seems to the superintendent of police that the information being given by the informant is of the cognizable case, then in such a case either the superintendent of police may himself investigate the case or appoint any officer subordinate to him who shall have all the equal powers as if investigated by the officer in charge of that police station. This was all about FIR. How is FIR being filed in a police station? Section 154. Section 150. Whenever a question has been asked to you, if you are a law student, a question has been asked to you regarding FIR and the powers given to the police officers to investigate the cases, you need to write both FIR related to the cognizable cases, information related to cognizable cases, which is mentioned under section 154 of the Criminal Procedure Code 1973, information related to the non-cognizable cases and investigation of such cases, which is mentioned under section 155 of the Criminal Procedure Code 1973. The same provision, the same funda applies for section 156 as well, but only the difference is in case of non-cognizable offences, the police officer does not have the authority to investigate the case without the permission of the court, and the police officer does not have the authority to arrest any person without a warrant. The police officer needs a warrant by the court in order to arrest a person. If you have been asked about to write about the powers of the police officers regarding investigation of such cases, then you need to mention section 156 to section 161 of the Criminal Procedure Code as well. Section 156 tells about the powers given to the police officers to investigate cognizable offences. Section 157 says about the procedure of investigating such offences. Section 158 states about how the report of such information is being submitted to the magistrate. Section 159 states about the powers given to the magistrate to hold preliminary inquiry or the investigation. Section 160 says about the powers given to the police officer to require the attendance of the witnesses. Section 161 says about the powers given to the police officers to examine the witnesses. This was all about FIR and the powers given to the police officers to investigate such cases. Thank you. Have a nice day.